Good evening, everyone. It's a great honour to welcome Lord Mance for today's OxfordSpeaks lecture. Lord Mance is one of the most distinguished jurists of this generation, with a career that has spanned practice at the bar, service at the highest levels of the judiciary, and major contributions to both domestic and international law. After studying law at Oxford, Lord Mance was called to the bar and went on to build a highly respected career as a barrister, specialising in commercial law. He was later appointed to the High Court, then the Court of Appeal, before becoming a Justice of the Supreme Court of the United Kingdom. From 2017 to 2018, he served as Deputy President of the Supreme Court. Beyond the courtroom, Lord Mance has played an important role in strengthening dialogue between legal systems. His work has extended to international arbitration, comparative law, and judicial cooperation across jurisdictions. Today's conversation will offer us a valuable opportunity to hear from someone who has not only witnessed but helped shape some of the most important legal developments of recent decades. Please join me in welcoming Lord Mance.
Thank you very much for that nice introduction. Would you like me to say a little bit about my career? And then perhaps we'll have some questions. I think for the most part we should have questions. But it's a pleasure to talk about it. And I have to say at the outset that it was rather fortuitous career in the sense that I was originally a historian and I got into Oxford in order to read history. And for entirely the wrong reasons, probably, I switched to law, having read actually a book during the long vacation about the sad tale of someone with a history degree who ended up washing the windows, cleaning the windows on his old school. More seriously, I thought that law might offer something more practical than history. I think that's unfair. I believe that the history faculty at Oxford offers a very diverse range of possibilities as later careers, as indeed you can see if you look at the careers of people who do history here. But anyway, I found law interesting and decided, so to speak, simply to carry on after I left Oxford. I actually had a choice whether to do various things then, but the one I chose was, again, a good one in retrospect. The professor of jurisprudence would tell you that the best thing is to live with your decisions once you've made them, actually almost irrespective whether they're good or not. And I believe in that. You should make decisions work and not regret them afterwards. Anyway, the decision I made was to go to Germany, and it's given me a lifelong interest in Germany and also in international affairs, particularly at the European level, and also friends in Germany and affection for German literature and culture, and even a German godson. So I've just written an article actually for a German legal publication about my German life, which caused me to extract all the bits of German involvement that I've had, and they've been fun and particularly given rise to good friendships. Not too many people speak German, so it's quite productive, gives you opportunities in that respect. The legal career, which as a barrister I was lucky enough to follow, had lots of diversity, and I think that's one of the great joys of the law, particularly at the bar, but nowadays lots of people who start off as solicitors change to the bar, and some go in the opposite direction. So there's much more flexibility today than there used to be. But the legal career I followed involved work as a junior, pretty scarce when I started. I always date the start of commercial work, particularly in the trade and shipping area, to the first Gulf War, so early 70s. But it then became rather busy. In those days, there was just one commercial judge. Now there are a large number of commercial judges, probably about 12, I should think. Anyway, you were led as a junior, then you began, as you became more successful, to do cases on your own behalf, even against silks, against QCs or KCs, as they now. And then you, if you were lucky and good, you became a KC, and that opened up the possibility of practice abroad. In my case, I spent a lot of time in the Bahamas. There was a major scandal on the Malaysian Bumiputera Fund. That was a fund which was supposed to promote the welfare of the indigenous Malaysians. In fact, it was diverted to the purchase of expensive property in Hong Kong and to the personal benefit of those who abstracted it from its proper purpose. And there was an enormous scandal, and it led to a murder. One of the Malaysian investigators was murdered in the Regent Hotel, Hong Kong, using the belt which he had foolishly taken from one of these swimming garments they give you in the Mandarin Hotel. The belt was rapidly traced to the Mandarin Hotel, and he was actually arrested, but not, of course, the people who'd ordered him to do the murder. There was also a suicide. Sadly, one of the lawyers, the solicitors involved, committed suicide, and we had to lock up everything in fireproof cabinets every time we ceased to look at the documents. That was quite a sensational case, and then I did another 6 months in the Bahamas. So as a silk, you had opportunities which you wouldn't otherwise have had. Then as you become more senior, you sit part-time as an arbitrator or as a deputy high court judge. And then, as you heard, if you get in those days, you were asked whether you wanted to go on the bench. It was the tap on the shoulder situation. And I have to say that my career was almost entirely achieved by that sort of promotion, which it doesn't give me much credibility. But at the end of the day, I can be proud to say that I did apply for and compete for a job which was the Deputy Presidency of the Supreme Court, which I got. So I did at least gain a certain amount of cred at that point. The bench is different at each level. I mean, some people found the High Court lonely. I never did. I thought it was an opportunity to get people on both sides to realize that they're in a cooperative venture, that basically they are aiming, or should be aiming, to help the court get at the right answer to the case. And adversarial conduct should take place subject to that constraint. And by and large, in the commercial court, it does. Obviously, there are exceptions. Sometimes people don't behave quite as you would like. If you get promoted to the Court of Appeal, that's a different exercise. You're working cooperatively with 3 people, which is very interesting. Your range of work is also broader. I mean, as a first instance judge, you do crime. Commercial judges don't go out on circuit as much as other judges, but we did go out on circuit for 6 weeks a year, and that was very interesting. You got to know people around the country and see the law from a different angle. But in the Court of Appeal, you've got a wider diversity of work, interesting colleagues, and then if you go to the House of Lords, as I did, or subsequently the Supreme Court, you've got a selection of the difficult and interesting cases, and which you resolve collegially with 4 others usually, and that is a very fascinating experience. And if you do it for a long time, as I did, you gradually begin to feel that you actually know and own the jurisprudence, are responsible for quite a lot of it in quite a lot of areas. Now, obviously, looking back, one's contribution doesn't always get taken on or even survive. There are cases where I can see that subsequently the court has taken a different trend, and that's interesting to see, but it's inevitable. Things which you were interested in, like the extent to which our test for judicial review, basically rationality, traditionally rationality, has been modified in the light of the Human Rights Convention and in the light of the development of the common law, which I'm a firm believer in. Cases considering that area of activity haven't been taken up fully in looking back, but they have to a degree been taken up. It's one of the areas where European influence has been mutual and might have been even greater, but for Brexit, I think would have been even greater. We used to have very fruitful conversations with continental judges, and we used to think in similar ways. We found to continental domestic judges when it came to considering the approach taken in the Luxembourg court, for example. I was lucky enough to do a lot of other activities. Council of Europe, I was the first president of the Consultative Council of European Judges, which is a body which was founded in 2000, has ever since then produced some quite useful reports on various things, particularly, take the classic subject of independence of the judiciary, how you appoint them, and how the judiciary should manage itself. But I was also chair of a House of Lords subcommittee on European law and institutions, and we wrote a large chunk of a very big report on the Lisbon Treaty, which was interesting. And subsequently, I was chair of the House of Lords Conduct Committee, which was also interesting for a different reason. And then I was asked to join the committee of 7 persons who scrutinise candidates for appointment as judges or advocates general in Luxembourg. I'm the only British judge ever to have done that. Since Brexit, of course, we don't have a judge on the committee anymore. But that was an extremely interesting exercise. We were chaired brilliantly by Jean-Marc Sauvé, who is the president of the Conseil d'État in France. And we also had the president of the German Constitutional Court as a member. And that was an extremely interesting exercise. We couldn't do as much as we might have done because, you probably know, in Europe, if each country puts forward one candidate to be judge appointed by that country, so we never got a choice. All we could do was look at one candidate at a time and decide, is this candidate good enough? Are they the right person? But we were quite stringent. We rejected quite a high percentage. At the outset, it was absolutely evident that the system was essential. It came in through the Treaty of Lisbon under Article 255, and it was very heavily supported by the British government. Anyway, I think it's a very good system, and I think it could have carried further. Rather sadly, for example, when they needed to expand the General Court, they didn't need to double it up. Every country has a member, so 27 members. They didn't need to have 54. And so there was, for a time, a proposal to have an open competition, to appoint an extra 13. But sadly, and this is no secret, the smaller countries of the European Union objected because they said, we will never have candidates good enough to fill any of the places if you open it to competition. And I think that's a rather sad comment on non-European attitudes. But perhaps all that I've said indicates so far that I wasn't too unhappy with Europe, and I certainly enjoyed my interrelationship. Since I retired, which was in 2018, I still sit in the Singapore Court of Appeal. I was out there 2 weeks ago, and that's an interesting international court. It's a phenomenon. The modern world seems to have generated international courts, particularly in the Middle East. I was the Chief Justice of one in Kazakhstan for 4 years, which was very interesting, a common law court in the heart of Asia, and separated. I mean, Kazakhstan is not free of corruption, but we were deliberately set up to offer neutral, impartial justice, and we were set up by a separate constitution from the country's main constitution with an internal right of appeal so that there could be no contact with the rest of the country's judicial institutions or political. The only contact had to be that they had to undertake to enforce our judgments, even when we gave judgments against the government. And we said to them, I used to say to the Minister of Justice, if you don't enforce them, we all go home. this court, which you put a lot of money into, depends upon you respecting it. And they did. And they made it, whilst occasionally slightly grumbled, they made it into a matter of proud announcement. There are judgments against the government for 20 million, and we pay them. So that was an interesting experience. But these international courts, like the Singapore one, with judges from other jurisdictions, in the case of Singapore, most of the judges are local Singaporeans, but they bring in one or two from elsewhere. They're a very interesting phenomenon, and one which I think shows the strength of the common law. Obviously, they're, in a sense, competition to London, but it's not competition which London should resent. London has to stand up for itself, and I think does so. I've done a lot of arbitration since retiring from the bench, both private international law, private disputes, and investor-state disputes. And more recently, I've been engaged with some German judges in writing a book on a comparison of German and British constitutional law, which we've nearly finished. Apart from that, I am engaged in private activities near my home, particularly relating to the environment and music. So, is that an introduction that gives rise to any questions?
I thought I'd start off
Yes.
with you. I thought I'd ask you a little about what keeps the law engaging for you today. Since leaving the Supreme Court in 2018, you've arguably been busier since arbitrating and judging in courts across the world. So what is it that still pulls you in? And does this feel like a new trajectory for you? Or is this sort of a continuation of the work you'd always done?
It's different in the sense that arbitration is different from litigation. Arbitration is a bit more of a jungle, and you don't always have the good order that you have in litigation. But if I criticise myself, it would be to say that I'm doing something which is slightly too similar to what I've done the whole of my career, but in slightly less, sometimes less satisfying ways. But having that said, I mean, arbitration is the way in which people resolve disputes, and I think it's quite useful and important for people like me to try and make a contribution. The only trouble is it's difficult quite to, I have found, to judge the size of your contribution which you're being expected to make. In other words, you can take on a case and it can prove to last much longer and be much more involved than you thought, and also more difficult to get rid of. When you write a judgment, that's a relatively simple thing. You just write a judgment. Arbitration awards, the institutions which administer them insist on the most extraordinary formalities, and every procedural step has to be outlined, and so on. So the answer to that, I've found, is to get some young lawyer to act as tribunal secretary to help you. But it's still a little tiresome. So the answer is, I mentioned at the end that I enjoy my local activities, and they are a change. I mean, I'm the chair of a big trust, a music trust. We are astonishingly fortunate to be able to support music in North London, and I'm also the president of the Heath and Hampstead Society, which is very active in looking after both the housing side and the Heath side of where I live. So there are other things than the law, and I am trying to wind down slightly.
If I may now delve a little bit into the past. When you were a Supreme Court Justice, you said you rewrote judgments, Kennedy being one of them, because of colleagues' inputs, and that there's more scope for collaboration the higher you climb. Could you take us inside that and what it actually looks like when strong-minded judges change another's mind, and how does that strengthen the final judgment?
I think hugely. It's also fun. You need to retain an open mind beyond the initial deliberations, which I think perhaps mistakenly in the Supreme Court we almost always had immediately after the end of the case. My personal feeling is that it might be better to do what they do in Germany, actually, which is after the end of a case, set a period at the end of which you then have the deliberations. But anyway, that's not the UK approach or tradition. So it's important not to completely overcommit yourself in the immediate deliberations. Even if sometimes you do commit yourself to the point of saying that you will write the judgment. Usually the presiding judge decides who writes the judgment, but supposing you get asked, you can still change your mind, and there's at least one case, it was a Scottish case, where all of us having agreed what the answer was, when I went away to write up the judgment, I convinced myself that the opposite was the answer, and so I circulated a draft saying, I'm sorry, I've changed my mind, here's my view, and everybody else agreed with that. So that's very satisfying, and I think we were right to reconsider. But where contribution is particularly valuable is if there is a real division in the court, then you can at least seek to soften or qualify or modify, sometimes by persuading your colleagues not to put quite what they put, but saying, wouldn't it be better to do it this way? Sometimes, if that doesn't work, by yourself introducing in your own judgment qualifications, which at least then can be read in subsequent cases by lawyers and can be used as a basis for a slight shift later on. So, no, the interchange was, of course, what made being in appellate courts such fun.
How do you know when to keep working towards a common position, or when you should break away and dissent? And how can dissent in such a way have value, or does it ever sort of, take away from the point of working with other judges?
No, I think dissent has huge value. I think it's one of the great strengths of the British common law approach. We view it as a strength. To be undertaken, as I think you're suggesting, within limits. You don't want to dissent in every case. A colleague of mine said, Simon Brown, actually, Lord Brown, said at one point that he only dissented when his natural indolence was outweighed by his indignation at the stupidity of his colleagues. That's putting it a bit strong. I mean, you dissent if you feel that things are going wrong, or if you feel it would be valuable for the future to have the other point. There is also something rather holistic about a dissent. I remember receiving a letter, I think at least 2 years after we'd heard a case, from one of the litigants who said, I felt I couldn't wait any longer before writing to say how much I appreciated your dissent, even though we lost. At least someone had understood our position. And so there is that societal benefit that can exist. But common law systems are different, of course, from civil law systems. In civil law systems, the unit is not so much the judge as an individual, but the court. And so you get judgments of the court, which are often heavy compromises, sometimes by omitting problems, glossing them. And I'm afraid that's true of the Court of Justice in Luxembourg. One of the troubles is they don't allow any sort of dissent. They insist on a entirely collegiate output. And personally, I think that has some disadvantages.
So you touched a little in your introduction about your work in Kazakhstan, and as a Russian student, I'm quite interested in your work in that region. Of course, you mentioned that in Kazakhstan, corruption is quite prevalent, though of course you helped build a court where you created an English-style common law court inside a country whose own institutions work very differently. Did it genuinely feel like an independent island of justice from the inside, And were there any moments where you really had to fight to preserve the values that upheld the court you created?
No, I would say that the Kazakh government was actually supportive, continuing to say. I mean, it put a lot of money into it, so it's got a heavy incentive in that respect to make it succeed. It put a lot of publicity into it, and we were on good relations with them. We did a lot of work with Kazakh judges, training, that sort of thing, and meeting. There was never really a crunch point. The interesting cases were the ones where we had to make judgments delineating our competence, the things which we could sensibly try, and the competence of the ordinary courts. And at an early stage, I tended to obviously to write the judgments which were of real importance on that sort of point, because they were structural. And I wrote a judgment on the extent to which arbitration under our system was subject to the general Kazakh rules and laws relating to arbitration, and effectively saying, no, our system is completely independent. We had an arbitration centre attached to us, and we said, no, it operates on its own rules, it's subject to our jurisdiction. And then we had another case, which was an interesting one, whether we could enforce in our system, within our jurisdiction, a British judgment which had been obtained without actually any obvious jurisdictional basis, I think. Anyway, it had been obtained, and enforcement had been refused in the ordinary Kazakh courts. So we were effectively being asked to compete with them as a place where you could enforce judgments. And I said, no, that wasn't within our jurisdiction. It wasn't. We had a jurisdiction basically based on consent, where the parties consented, or where it was a matter within the particular arbitration and business centre which we were charged with administering. So it was that sort of case which was interesting, but we never had any political problem. They committed themselves and supported us.
That's really nice to hear, actually. I could stay here all evening asking questions, but I should probably move on to someone else.
I'd like to open it up to the floor. If you have any questions, just raise your hand. It could be anything. Yeah.
When you spoke about your time as a justice in the High Court, you said about the sort of need for cooperation even within the sort of adversarial system we have here. Do you think that would have been influenced by your time in Germany, or if not, why? Is there a particular reason you felt like you felt much stronger in that direction?
I think there is an inherently collaborative element in our system in any event, and that is because judges were formerly either barristers or solicitors, mainly barristers, and because barristers or solicitors who conduct cases in court generally want to keep open the option that they might go on the bench themselves. And so behaving badly is something which they don't, that doesn't encourage. But personally, yes, I think I would say I've spent not a huge amount of time, but some time with German courts, both at the appellate level and first instance judge. And they are more conversational, so they think nothing of being in touch by email or by even by phone with parties, although that is difficult because you have to have both parties. But they discuss the case and the difficulties, and I thought that's an approach which one could have a bit more of in the British system. But basically, I think it's what courts should be for. They should be seen as places where you seek to achieve an acceptable social result, societal result, one which is to the benefit actually of society. So it's a collaborative approach.
Any more questions?
Yes.
I have a question that's quite specific to a particular area of arbitration. I'm not sure if you've read the case of Cian and Halimeda International, which is got to do with, well, I guess
What's it
it's
about?
a more general question about favoring the creditors in terms of insolvency proceeding when there's an arbitration clause. So,
Oh, yes. Yeah.
yeah, so I guess I want to get your views on that case, particularly because you also sit on the Singapore Court of Appeal, and the Singapore Court of Appeal has famously adopted a very different stance from the Privy Council's holding in Siam, and they've held that there's no additional test for whether the debt is genuine and substantial, and that as long as there's a disputed debt, they will go in favor of arbitration, and the court will not grant the winding up petition. So I wonder what your thoughts on that debate are, and how you feel courts should go in the direction, what steps courts should take to support arbitration better.
Well, one hears a lot about the need to encourage and respect arbitration, but I'm not sure I would carry it to the extent to which you just told us that the Singapore court carries it. Was that at an appellate level or first instance?
Yeah, the Singapore Court of Appeal just released another judgment.
How interesting.
Singapore Commodities Group and Founding. That follows.
Which overseas judge? Was there an overseas judge on it?
No, I don't think so. I think it's a local judge.
Yeah. You think, because it'd be 3 judges if it was an appeal.
I think it's all 3 local judges.
Yes, I mean, my feeling on that is that there comes a limit to the respect one should have for arbitration clauses. The reality is that debtors who refuse to pay without any excuse are too many in number. They are able very often to deploy procedural devices, mechanisms, applications in a way which is designed to, understandably, to put off the evil hour. And the idea that simply by saying there is a dispute, you can generate an arbitration and stay a court judgment, prevent a court judgment being obtained against you, is, I think, one which I would be a bit cautious about. I rather gather what I think I've read the case, actually. I know I've read the case. It was Privy Council, was it? Yeah. Well, I think I rather favour that decision simply because I do think in the modern world we need to draw some limits to the extent to which lawyers earn fees fighting or arguing hopeless points, just to stave off the evil hour.
No, thank you for that. That's very helpful. I agree with that.
There's a public interest in
Yes.
getting cases tried quickly and finally, and the law's delays are too many already. So I'm in principle against situations like that, or situations where the same point is endlessly litigated in different countries, which is another area.
Thank you so much.
I'd like to ask about an area of law that I'm currently studying, which is administrative law. And you've adjudicated in a lot of cases to do with judicial review. A specific case I'd like to ask about is KU and Foreign Secretary in 2015, where you relied on your earlier dictum in Kennedy, where you stated the common law no longer insists on the uniform application of the rigid test of irrationality, once thought applicable under the so-called Wednesbury principle. You use this to show that judicial review is increasingly contextual, rather than tied to a single rigid Wednesbury standard. Do you think that the decision in KU illustrates the flexibility of modern judicial review, or rather its limits?
The decision itself?
Yes.
Well, I mean, the decision itself was, I think, understandable. We were being asked to hold that there should be an inquiry into something that had taken place long before the principles establishing the possibility of such an inquiry were even thought of. And in the 40s, when, in relation to which memory is anyway short, there was a tragic underlying alleged massacre, and so that's the other side of the argument. But I think so. I mean, you wouldn't expect me to quarrel with the outcome in KU. What aspect of the reasoning is it that you question? I think the reasoning which interested me in that case was the extent to which we would automatically or axiomatically incorporate into UK law principles of customary international law. And we held in that case that although in the past it's always said that customary international law is part of domestic law, and that's why we have a law against piracy. There's no statute which says piracy is a crime, but customary international law and domestic law do. But we effectively said those days are past. Countries have the facility to pass legislation and do pass legislation. If there is an area which one would expect to be covered by a statute, particularly a criminal statute, then, and it isn't, then you assume there's been some sort of tacit choice not to legislate, and you don't read in a whole lot of new criminal provisions, which anyway would probably require specific regulation. So I think KU was, that's the aspect of KU that interested me. Is there another aspect?
Well, you talk a lot about, I mean, you imply in the judgment that it's a lot to do with context, the context of each case when it comes to irrationality or...
Yeah, no, I stand by that, and we said that in Kennedy too. And that, I think, is one of the areas I mentioned earlier, that I wasn't sure my ideas had been fully taken up, because basically I was trying to say that leave aside areas like European law and European human rights law, where proportionality is embedded, even in common law areas, other common law areas, the test of rationality had a flexibility about it that enabled, in some situations, quite close review of governmental action. If you were dealing with life and death, or prison or not prison, you want something which is close to proportionality, something which enables you to weigh the seriousness of the interests which are being affected, the compelling nature of the reason for ignoring them or not giving effect to them, and to undertake a really quite radical balancing exercise. Traditionally, the common law hasn't been able to do that. You probably all know the famous case of Smith before the Human Rights Act about homosexuals in the armed forces, where, again, Simon Brown, Lord Brown, opened his judgment famously by saying Lawrence of Arabia would not be welcome in today's army, and yet could not find a solution in the common law for that sort of situation. And I think maybe today we would find a solution. I certainly would hope that we might, because I think that the common law should have slightly greater flexibility than is implied if you simply adopt a test of rationality. I mean, rationality means saying something which is sensible, whereas I think the test ought to be more contextual, more flexible according to the circumstances, and more respectful of, I think, of values such as those which apply under the Human Rights Act.
So do you think that any test would be possible when it comes to these sorts of cases, or do you think that it's fully down to the discretion of judges to decide based on legislation and human rights?
Well, I don't think it is down to the discretion of judges. I think, on the contrary, I mean, proportionality is an attempt to systematize and to govern the decision-making process. So, in a sense, it's more ordered than the common law. The common law seems to take one stab at, we can review it on one ground, rationality. Whereas I think, as Lord Steyn said in one of the earlier cases, proportionality looks at other factors in an ordered way. This is one of the areas where actually we got to the point of citing the German Constitutional Court in one of our judgments. I did, and because we'd had discussions with them about it, and because proportionality actually originates in the German Constitutional Court. It's not a pan-European concept. It comes from the German Constitution, and they are the developers of it, therefore, and they know what it means. And we were told, I remember, by Professor Dr. Gertrude Lübbe-Wolf that it was a concept which, as I've said, enabled you to approach different cases according to context in different ways with a greater or lesser degree of scrutiny, but it did order the way in which you approached, the classic four-stage approach, and I certainly thought it was capable of extending across the whole field of British administrative law without sort of undermining our whole system in some way, or making every governmental decision subject to enormous scrutiny, which is what the government's always frightened of course.
Yeah, and just connecting back to human rights, do you think that human rights adjudication inevitably requires judgments that are sort of quasi-legislative? And what I mean by that is judges not only have to look at what the law says, but also whether the interference with rights is justified. For example, when a court balances privacy against freedom of expression or liberty against security, is it still performing a distinctly judicial task? Or is it making the kind of social and moral choice that belongs primarily to Parliament?
I certainly don't think the latter. I think that judging is almost always involves balancing of interests, and the suggestion that judges are being political simply because they are weighing competing interests would mean that you wouldn't have any judges at all. Where matters become sensitive is under the Human Rights Act in areas such as it covers, where you are taking decisions on matters which politicians have strong feelings about, and perhaps the public, I mean immigration and so on. But I think that is almost inevitably the result of modern life, really. It's unavoidable. I think you wouldn't resolve it by abolishing the Human Rights Act or coming out of the convention, because people would then fall back on the common law and be asking for similar factors to be taken into consideration. It would be less easy to do that, but nonetheless it would be done. And the fact that judges make decisions about particular cases by balancing all the factors, the fact that they make the law by balancing the factors and deciding what the law is ought not to be a secret and ought not really to be a surprise. For a number of hundreds of years, perhaps, judges pretending they were nothing but automaton who produced a result when you fed in the facts, but that's never been the case.
Interesting. I'd like to open it up to the floor again. If you have any more questions. Yeah, Philip.
Looking back to your career at the bar, what kinds of personal qualities and skills do you think are the most important to be a good advocate?
Yes. The most basic is to, you have to assume a decent intelligence. Then you have to assume, I think, engagement and devotion. You have to be prepared to do the work. The vast bulk of the work is never seen in court or anywhere else. It's 90% like an iceberg. Only you realize that you've mastered all that material and thought about it and seen what bits you can use, the 10%. And then when presenting it, you need to know how to marshal it and how to present it. We were talking informally before about the extent to which people repeat themselves and don't have a structure to either their written or their oral submissions. You need to know where you're going and how you're going to get there, and you need to do it, please, without boring the judge. I mean, which document would you read first if you are presented with an 85-page set of submissions on one side, or indeed in an arbitration, 450 pages would not be unfamiliar, and on the other side, a 50-page or a 100-page to take the arbitration? Which document would you read first? And I have to say that on occasions, almost out of sheer annoyance at the length of some submissions, I made a point of reading the shorter first. And of course that ultimately doesn't affect the case, but it does mean that possibly at that stage you're at least more certainly aware of the facts, the matters which on one side matter at an earlier stage. I think the real gift of an advocate is to know the points which the judge is going to be interested in, or the court is going to be interested in. If you tell them a lot of things they already know or will have picked up, you shouldn't mistrust courts. You must assume they've done their work, and that you don't have to tell them everything. Certainly you don't have to tell them everything twice. So give them credit for having thought about the case, and really work out what are the difficult points, which if they are clever, the court will come up with anyway, and be ready to answer that point. I think, in other words, always have an answer to the problem posed by your weakest points. If you've got weak points, know what they are and know how you're going to deal with them. Otherwise, as I usually say, perhaps you shouldn't have allowed the matter to get to court if you don't know how to deal with the weak points.
Yeah.
What are your opinions on recent versus jury?
I very much doubt whether they're going to deal with the problem of delay. That's the ostensible reason. I mean, I think probably we do set more store by jury trial than it necessarily involves. I mean, it's a culture, a tradition we're proud of. It's democratic. It's actually an interesting, another situation in which you work with people, you work with a jury, try and get on their side as the judge, get into their minds, help them. So it's, in that sense, it's a good system. But there are cases where you felt, does the theft of this coffee cup really need a jury trial? And I think there might be some room for a slightly lesser entitlement to jury trials in every case. I also think that in certain categories of case which are not covered by the recommendations, jury trial might be better substituted with something else. Take fraud cases, criminal fraud. And can we really say that it's the only way of getting justice? Of course we can't. They have a completely different system in Germany or France. So the idea that we're the only people in the world administering just criminal law is wrong. But it is part of our tradition, and it is one which I found very interesting, working with a jury. Didn't always feel that they got the right result. Actually, funny enough, mainly in, I'm afraid, sex cases, one felt that they didn't really possibly have experience of course, I didn't have a huge experience, but there were one or two cases where I just thought that the result was a compromise. We're not quite sure, and we'll go for a lesser verdict than rape, for example, indecent assault. But that was one never knows.
Any other questions from the floor? I have a question about. Yeah, sorry, go on.
I think you should go.
Okay.
Yes, I'm. Ruth, you'll be allowed to, but not as long as it's a nice question.
I have a question about your lecture you gave in King's College London in 2017, where you stressed that some international law issues are non-justiciable
Yes.
because they belong at the international level and not in domestic courts. I'm wondering, do you see non-justiciability as about legal incapacity, or is it more of a form of judicial restraint?
I think it's a bit of both. It's certainly a form of judicial restraint, and the reason one restrains is that the criteria you would apply are not really legal criteria. I mean, how do you decide whether someone deserves an honour? That's an example of prerogative power, the grant of honours, which is commonly thought not to be judicially reviewable. But I suppose, I mean, if somebody showed that a bribe had been paid for an honour, then possibly in the modern world that might be judicially reviewable. I don't know. But anyway, now taking an example, decisions of war and peace. We're not going to review those. Those are not really justiciable. We may think it's a very silly thing to do this or that at the international plane, but that's a social judgment. It's not really a judicial one, or certainly not one that judges should lightly get into.
Interesting.
Maybe if there was a strict rule, that, as in America, that you should consult Congress for certain decisions, then maybe one might expect a judicial system to have a possible role then. But I'm not opining.
Interesting. Yes, please.
I wonder if you could give us a flavor of your philosophy of judging. So we know that it's weighing of competing interests. We know that your role in society is sensitive to social concerns. What's the role of precedent in the way you think about how to judge? As you know, philosophers have written a lot about exactly what role precedent should play, and I wondered what a real judge does.
I think precedent is part of the glue which keeps the system together and actually makes it equal and just. Because it's an inherent quality of law, or should be, that it is reliable as far as you can achieve that. Now, there are situations where, as I said earlier, judges do find themselves effectively having to address new problems and to make new law, and we no longer try to cover up in the way that legal tradition used to be by suggesting that we're merely revealing what has always been the case and that the law goes back to Saxon times. So in that sense, I think that precedent has an important role, but we all know that it is not the only test. Sometimes you have to reconsider, and I suppose in a sense maybe there ought to be some compensation then for people who may have relied upon the old understanding and are bitterly disappointing when you do change what had hitherto been understood. But I don't see precedent myself. In general, I've never found it a hindrance. I found it an inspiration. I found it a guide. I found it something which I would seek to adhere, respect, as long as it remained respectable in and giving intervention a relatively limited scope if there is clearly established precedent and there's no compelling reason to jettison it. Does that help at all?
So you don't think of precedent as a kind of lexical, having a lexical priority. First you check and you see, is there a reasonably clear precedent that actually governs this case, which would be a normative judgment. And if the answer is no, then you do the hard work of judging. Because that's what many German judges will claim that they do.
No, I think that is right. I mean, if there is a reasonably clear framework of precedent, then it takes a particular strong set of considerations before you jettison it and start again. If there isn't a reasonably clear precedential position, then you're in the position effectively where you are innovating. You are, and then you have to undertake the full balancing exercise yourself, identifying the relevant considerations and balancing them against each other. But there is, usually I've been happy with precedent and found quite a lot of guidance in most cases. You have almost a sense of where the law is going in a particular area, which is derived from a general familiarity with the precedents in the area. You may need to read them closely to decide whether in fact what edges they set, whether they in fact go quite as far as you think they do, or as quite as far as to cover the particular case.
Any other questions from the floor? Do you have any other questions? Yeah.
As I've been reading about cases you've judged on, something I think I've started to understand is that law can often be a balancing act between different values that we hold to our societies and civilizations. I was reading about Bank Mellat, which was the Supreme Court's first secret hearing, and Belhaj, which concerned the alleged complicity of UK officials in rendition and torture. Where, in your experience, is the hardest line to draw between a court's justice to practice justice in the open and genuine national security measures? And I was wondering if you could tell us a bit more about the difficulties and experiences you had working on these cases.
Well, there are some rules in these areas, and one of the rules is that you give due respect to foreign states acting within their boundaries, and you also give due respect to the legislation of foreign states within their boundaries. And the corollary of that is you don't give so much respect to them if they act outside their boundaries. The other factor, which is one perhaps which has less weight, is that you pay some attention to potential embarrassment for your own state if you're deciding on the conduct of foreign states, even if it's outside the foreign state's boundaries. But that, to my mind, is not a very happy qualification, and it's not one which I can think of as having been applied in any case. It's been mentioned. Cases like the Belhaj case were certainly sensitive, but we girded our loins and we said that they had to be adjudicated on the basis that, assuming a foreign state to have been involved, as was the case, they had no privilege when they were acting outside their jurisdiction, and when what they were doing was effectively kidnapping people and handing them over to totalitarian regimes. So I think that's a case where eventually, as you know, the government paid up large damages, and I think that's a case which shows us adjudicating on effectively matters close to our government's heart, but in circumstances where you can always sue your own government about its conduct within the jurisdiction. Our government doesn't have any prerogative to assist kidnapping anyone anywhere in the world, so that aspect of the case caused no problem. What caused problem in Belhaj was the foreign governments were involved, so we had to delineate to what extent that precluded adjudication, and it didn't.
That's very interesting, thank you.
I'll ask one more question, if that's okay. Speaking of jurisprudence, I think last week we were talking about the moral obligation to follow the law. I was wondering your thoughts on whether you think there is a moral obligation to obey the law simply because it is the law and not because certain laws are just or unjust.
I think I'm going to pass on that question. I think I would say that on the whole, if you sign up as a citizen of a society, you're basically signing up. You ought to believe in the laws it passes, and you certainly ought to believe in them to the degree that you don't depart from them simply because you disagree with them. think I'm a social animal, and I think I believe that I should subscribe to the society I live in. But I might want to change the laws, and that's a different matter. You said about that in the ordinary way, rather than simply ignoring them or flouting them.
Yeah. Great. Are there any more questions from the floor? In that case, I think we'll wrap it up for today. Thank you so much for coming. Please join me in thanking Lord Mance.
Well, thank you. Yeah, thank you. Thank you very much.
Thank you.
All right.